Hello, my name is Jonathan Burge. I'm making this video to tell you a little bit about myself and how I defend drunk driving cases. I'm an attorney who's been practicing in Hawaii for nearly 20 years. I've represented thousands of people accused of driving while impaired. Prior to becoming a lawyer, I worked for the Honolulu Police Department for nearly 10 years, where as a police officer working primarily in patrol, I've actually arrested hundreds of people for DUI and testified dozens of times in those cases. Finally, as an attorney, I've taken DUI cases all the way to the Hawaii Supreme Court over a dozen times, with numerous cases setting precedent in the state of Hawaii that'll follow long after I'm gone. Now, as far as what I'm going to tell you in this presentation, what I'm going to do is talk generally about drunk driving defense. Every case has unique facts that'll make it a little bit different, a little bit easier, a little bit harder to win. But this is just general DUI defense, things that can be done in any case. As I like to say, every case is winnable and every case is losable. The different things that are involved are judges, prosecutors, and witnesses. There's three parts to every DUI case. You have your revocation office, which is the office that deals with your driver's license, and it's having to do with all that paperwork that the police gave you right after you're arrested. There's tickets, which sometimes they give you and sometimes they don't. And then there's the court side that deals with a criminal conviction on the DWI case. So as far as the first office goes, the revocation office, that part of this proceeding only deals with your driver's license. And over there, there's a low preponderance standard. Preponderance means probably. So if you're probably drunk, they can take your license there. It's also kangaroo court, which means think of it like Mothers Against Drunk Driving is running the place. They want your license badly and will do everything they can to take it. That's all the bad stuff. The good stuff is that you usually don't have to go there. I go there for you. And on a refusal case, the standard's a little different. There, they only have to show that they properly informed you of the standards and that you refused. If that happens, they double the regular revocation period. However, I'm often able to get that period lowered or reduced because either they didn't properly inform you of the sanctions or you didn't understand them. So even if you start off double with a refusal, most times I can get it lowered. It all depends on the facts of your case. Now, if you get caught driving after an administrative revocation is in place and you don't have an interlock device installed, you face mandatory jail. 3 days the first time, 30 days the second, and 1 year the third. So it's very important not to just forget about or don't go through this revocation process, because basically it's automatic based on the police reports. However, I win more than I lose, and it's based on all the technicalities that are involved there. So it behooves you to try and win that part of the case. And basically I set all that up for you and go there for you. So don't forget about the administrative process. It may seem like it's nothing or it's not there, but that process is kind of collateral to your criminal case and you have to deal with it. It's very important that you don't delay too long in getting this case going. That's because the revocation office has to give you a hearing within 25 days of your arrest, as long as you request that hearing within 6 days of them sending out the letter. So there's a lot of technical deadlines, but the bottom line is the revocation hearing will occur prior to your arraignment, that date that the police gave you when you bailed out. So what I do is I set up the hearing for you, I get your police reports, and I subpoena witnesses all before that first hearing. That first hearing is going to come up so fast that we're only going to have about a week or so to subpoena witnesses. If we can't subpoena them, your hearing gets continued and your license doesn't get extended during that continuance. However, if we do serve the officers before the hearing and they don't show up, your license will get extended during the continuance as long as you had a valid license at the time of your arrest and as long as the license hasn't expired. So as I said, there's a lot of technical issues that go with the revocation process, so it's important that you don't delay and you get the ball rolling on this very quickly. The next part of your DUI case may very well be a traffic ticket. As I said earlier, sometimes the police give tickets, sometimes they don't. If they do give you a ticket along with your DUI, don't pay the ticket. I combine it with a DUI case and it usually gets dismissed. The court proceedings is the third part of every DUI case. The court proceeding is a criminal conviction and a second chance at your license. Remember, as I told you earlier, even if you win the revocation, if you lose in court, they still get your license and it's not double jeopardy. The standard is much higher. It's the highest standard of any type of case in our legal system beyond a reasonable doubt. In the criminal case, you usually don't have to go to the first arraignment and plea date, but you go after that with me. I go to the first one for you, that date that the police told you to go to when you bailed out. Although jail is possible, it's not probable on a first DUI. Nobody's ever gone to jail on me yet, and I don't think that you would be the first. If you have a subsequent drunk driving case, then jail is part of the mandatory system, and that's something we'd have to talk about. But on a first DUI, it's not probable, it's not going to happen. The entire process takes about 6 months, and you usually don't testify, so it's all on me, and you don't have to be prepped for trial. And finally, I file motions based on the Fourth Amendment, Miranda, and other technical issues in your case. Later on, I'm going to show you some examples of cases I've done and basically successfully argued based on those motions. I've filed hundreds of motions and had many granted. And basically what that does is it gets rid of any evidence that's taken as a result of the illegal seizure or Miranda violations. Now at this stage, I'd like to walk you through some of the general procedures in both the administrative proceedings and the court proceedings, and walk you through an actual case that I did. The case on the screen right now was a client of mine from August 2nd, 2013. You'll get a letter very similar to this in the mail about a week to 2 weeks after your arrest. What's important, very important, is the date and decision of mailing. You have basically got 6 days from the date that they mailed it, not the date you got it, but the date that they mailed it, to request a hearing. I do all those things for you. That's one of the ways that they try and screw you over. So this date and decision of mailing right here, very important. You can see here that this particular client blew 155, which is nearly twice the legal limit. And finally, you can see under here where he actually got a 1-year revocation of his license. So again, the form that you get in the mail is going to look very similar to that, and that's what's going to start the administrative process. So this is that individual about 6 months later, February. That was August, this is February, and we basically went there on 3 different occasions. And you can see underneath here what they say about the officer. 3 times the officer was served and didn't come. And basically that happens a lot because the officers can't be at 2 places at once. So if I happen to schedule it when they have court, so be it. The court side, this is how I win the cases in court on a general scheme of things. The Hawaii Supreme Court says that a witness can't testify unless they actually remember the events of what happened. A lot of times these police officers will not remember what happened months down the road. And when they don't, I can make motions to strike that information. DUI law is about taking a case apart. Everything starts off bad on paper, and it's my job to take it apart. One of the things that you'll see in your police reports, and I send your police reports to you as soon as I get them from the revocation office, is the standard field sobriety test report. This is the same field sobriety test report that came from the other person that I showed you. And in every field sobriety test report, the police are supposed to ask you the questions that are up on the screen. Oftentimes they don't, but they're supposed to. And one of the things I do fight about and file motions on is some of these questions they ask without Mirandizing you. But also sometimes your responses can actually help you in your case, which I'll show you about a little later. Now this is the second page to the standardized field sobriety test. And there's three parts. The eye test is on the left, the walk and turn on the right, and the one leg stand on the bottom left. You can see here the different things that the police are looking for in each type of test. Each type of test, any check mark is made when there's something wrong. Any 2 check marks on any portion of the test is considered a failure. Here's the walk and turn. Again, any 2 check marks considered a failure. And look at all the little nitpicky things that they look for on these tests. And here's the one leg stand. Look at all the nitpicky things they look for there. And again, 2 check marks, a failure. This is the same individual that I showed you earlier, the guy that blew .155. You can see here that his field sobriety test is pretty horrible as well. Notice a little stick man in the corner. That becomes important later. And remember I told you about memory. Well, memory is how you win these cases. You're not going to win getting into a pissing contest between you and the cops. So you want to go and show that their memory isn't there, and by doing so I can strike that evidence or call it into question, and that's how you win. In front of you is actual transcripts from my client's trial, and again there's the same guy that blew the .155 and had the horrible field sobriety test. And if you read through, I'm the one doing the question, the officer is doing the answer. And you notice in this example where he says, I don't remember. Well, whenever an officer says they don't remember, they don't recall, it's like taking white out to those little checks on that field sobriety test. The simplest way to explain it is, if we can white out enough checks, you win. So that's my job. Try to white off the checks. Again, here's another example. Back and forth between me and the officer, and you can see him saying he doesn't recall, can't remember specifically. Again, it's white out, and it's great for my client. Here's an example of how the police will usually try to they'll usually try to testify in a general sense, and basically with a little bit of cross-examination I can get them to say they don't recall. As you can see, happens in this particular case. Again, I don't recall is good for whiteout. Remember the little stick man that was showing up in the field sobriety test earlier? Well, here's what he has to say about that. He doesn't remember it, so that gets whited out. And then finally, it takes some time for me to cross-examine someone on those forms, and after a while they just give up. And here's an example of that. Here's the officer trying to testify with regards to the leg raise, and he just gives up. Says he doesn't recall anything. So white out, white out, white out. Now before you is the court records for the same client of mine, the guy that blew the .15 with the 155 with the horrible field sobriety test. You can see here that he was found not guilty as to A1. A1 is the field sobriety test part of the case. A3 would be the breath test part of it. So the .155, there was another technicality, and he got his bail refunded. So this guy blew 155, horrible field sobriety test, was stopped properly, and he won both sides. I show you this example to show you that every case is potentially a winner, and every case is also potentially a loser. Depends on whether or not I can get in there and erase facts. So my job is to take away evidence. So that's what we try to do here. I have a number of tools that assist me in defending my DWI clients. This is a report from the National Highway Traffic Safety Administration. These are the people that actually designed the field sobriety test. And it was done in 1981 by the Department of Transportation. And when you get your case, the prosecutors will always try and have the police say, oh, it's done pursuant to the National Highway Traffic Safety Administration. Well, this is what the National Highway Traffic Safety Administration says about the walk and turn test, the one where you take 9 steps and turn around and come back. Basically, people with back, leg, middle ear problems or high heel shoes aren't supposed to do that test. If you're over the age of 65, you're not supposed to do that test. Well, the police make everybody do it, and I've used this numerous times to my client's advantage to win their case, because basically if the police are making you do something that you're not supposed to do according to their own standards, then that raises doubt. This is the leg raise. Again, leg raise if you're over 65, leg, back, middle ear problems, or overweight by 50 pounds or more. You're not supposed to do the leg raise test. But guess what? The police make everybody do it. Again, not following their own standards. If you have any of those problems, let me know, and I raise a separate motion for that. And again, I've used it many times, and it will assist you in your case. Remember, the police may have had you blow in this machine right here. It's the Intoxilizer 8000. Well, I have the operator's guide to make sure that they do that correctly. Here's the DUI manual. Basically, this is the manual that the police use to do the field sobriety test. It's many hundreds of pages, about 200 pages long, and it basically nitpicks and tells them what to do and what not to do. So whenever I do a trial, I nitpick right back at them and make sure that they do it according to their own standards. Once again, not doing it according to their standards is how you can raise doubt. I've done many appeals, over a dozen appeals to the Supreme Court in DWI cases. This was a pretty big case. Happened around November 2015. It made it possible, so we were the first state in the nation to throw out everyone's blood or breath test and throw out a criminal refusal statute. They used to say you could go to jail up to 30 days if you didn't take a test. The whole state of Hawaii, this was thrown out because of this case. And basically it established that when you take a blood or breath test, it's a Fourth Amendment search, and they have to follow the same rules, the same constitutional rules as they do in other searches. This is a case I did at the Hawaii Supreme Court in 2000. It changed the rules on looking at people's priors. Basically, my client had a lifetime revocation. I got it down to 1 year. And so that was my first precedent-setting case with appeals back in 2000. This case here kind of changed the rules a bit for the revocation office. In this case, they wouldn't allow me to have all of the officers come that does something in your case. For instance, in this case, an officer saw a red stop sign violation or something, and I couldn't subpoena them because that officer told another officer what happened. I appealed it up to the Intermediate Court of Appeals, and this case right here is precedent setting and basically establishes that if the officers don't all show up, we win the case. So now I'm going to show you a couple videos from these cases. One of them is the Juan case, and one is another case that I won based upon an illegal stop that the police did, and the judges didn't reverse it, so I had to appeal that for my client. So a lot of times these judges need to be educated, but they know me now. I've done many appeals, and they usually will listen to what I have to say.
Intermediate Court of Appeals has overturned a woman's 2013 DUI conviction, not because she wasn't drunk, but because the police officer pulled her over for the wrong reason. As Chris Tanaka reports, the court says seeing 6 people in the back of a small car doesn't amount to reasonable suspicion for a traffic stop.
I'm mad, and I'm frustrated.
Carol McNamee, founder of Mothers Against Drunk Driving Hawaii, can't understand how Justine Rivera's conviction for driving under the influence was overturned.
Had they not been stopped, this vehicle could have crashed. It could have ended in death for all the people in that vehicle.
It's not about drunk driving, it's about whether there was a constitutional stop or not, and there wasn't in this case.
A statute on the books in Hawaii is intended to strengthen seatbelt laws. However, there's a clause that states it's legal to have more passengers in the back seat than seatbelts.
So if there's 3 seatbelts, 3 have to be in seatbelts, and the other 10 can be not in seatbelts.
Hence, when the officer made the stop based on 6 people being in the back seat, it was deemed an illegal stop. Because of that, the evidence to support the DUI was thrown out.
The officer didn't know the law, misapplied it, and that's what the appellate courts found.
This officer who made the stop should be given an award. He cared.
While McNamee and Burge's opinions of the arresting officer may differ, their opinion of the clause may not.
Legislators, we're putting you on notice that we're going to be knocking at your office doors.
Language of the law needs strengthening. Chris Tanaka, Hawaii News Now.
It will affect every case that's currently on track, which is probably about 3,000 cases, and every case in the future until they fix their procedures.
A state Supreme Court ruling today puts thousands of DUI cases in jeopardy. It's taken 4 years to get a decision, and it has a major impact on all of Hawaii.
It means key pieces of evidence will have to be thrown out, and the way DUI arrests are made will have to change.
We were not expecting it today, the day before Thanksgiving. So we are not thankful for this opinion.
Mothers Against Drunk Driving is disappointed by today's ruling by the Hawaii State Supreme Court, which affects thousands of pending DUI cases statewide. In 2011, the legislature made it a crime for suspects to refuse to submit a breath, blood, or urine test. The penalty, up to 30 days in prison and a $1,000 fine. Suspects learn about the law when they fill out this consent form, which basically says take a test or face the additional penalties. Today, the Supreme Court ruled consent may not be coerced and that the threat of the additional penalties is coercive.
You can't criminalize someone exercising their constitutional rights.
Attorney Jonathan Burge represents Yong Shik Wong, who was arrested by Honolulu police in April of 2011. He originally refused to take the test, but Burge says the threat of penalties made his client change his mind. 4 years later, the state Supreme Court ruled the practice illegal search and seizure.
MAD is trying to save lives, and we are trying to deter would-be drunk drivers. If they refuse, you are taking away the major piece of evidence.
Blood, urine, or breath evidence collected in the 3,000 or so pending cases could now be thrown out, and it will be up to prosecutors to determine if enough evidence remains to move forward.
The timing could not be worse. This is a very high-risk time of year, dangerous time of year, starting with Thanksgiving and going right through New Year's.
DUIs cause a problem, but just because it causes that problem, you can't throw out everybody's constitutional rights in order to take care of that problem.
The implied consent form will now have to be changed. And with the holiday season kicking off tomorrow, it's unclear how today's ruling will affect enforcement. Honolulu police tell us officers are being notified of the ruling, but they wouldn't tell me if the form will be changed before any DUI arrest tonight.
For my regular district court non-felony DUI cases, I charge two different prices. Most people do regular, and for regular, what I do is I will subpoena whoever's necessary at the revocation office for you to lose, and then I try like hell to make them not be there so you win. If they do show up, unless there's some type of legal problem with your case, we accept it, move on with life, and you have the revocation. They don't show up, I win it, I get your license back. I also file motions attacking the case based on Miranda, Fourth Amendment, etc. But I combine those motions with trial so that we have one shot at the officers at trial. Enhanced is another way of doing DUIs, and this enhanced DUI is a bit more expensive, but it gives me a bit more tools to defend your case at the same time. What I do in an enhanced DUI case is I subpoena everybody to the revocation and I question them. If they come to the revocation, the chances are you're still going to lose, but what it does, it gives me transcripts of what they say under oath. And I can use those transcripts against them later. I'll show you some examples in a minute. For trial, I separate motions from trial. So instead of combining the Miranda or the Fourth Amendment motion with your trial, we'll hear that separately. I'll question the officers on it. Basically, it makes the state put their whole case on before your trial. And I'm able to question officers. I'm able to get transcripts of what they say to use that against them. And then finally, when we get to trial, that's the third time that we're talking to these officers usually. And I have these transcripts. And what the transcripts do is it gives me a few more tools to win the criminal case. Here's an example of someone right at the revocation office. And remember I told you about how we need to show their memory isn't too good. Well, this officer testified at the administrative revocation office that he basically had no memory of what happened on the field sobriety test. And he testified to all of that under oath. He couldn't come to the court later on and say, oh, I remember everything, or he could, but if he did, I would whack him pretty good for saying that he remembered. When he testifies here, he has no independent recollection. So this person, he won his case because basically it was won at the revocation office when the officer testified like this. He was caught in a corner, he couldn't change his testimony at court. The second way that it helps for this enhanced DUI is here. You'll see the field sobriety test on the walk-in turn test. So normally what I'll do is I'll ask the officer, officer, you say my client stopped walking on the first 9 steps. Do you remember that? And the officer will go, yeah, I remember that. I'll say, okay, well, what step did he stop walking? How long did he stop walking? How many steps did he stop walking? How did his feet look like? And most officers will say, yo, maybe I don't remember. And I'll say, thank you very much, wipe that out. Well, some officers will lie, and they'll say, it was a 3rd step for 3 seconds, took 2 more steps, stopped for 4 seconds, his right foot was in front of his left, etc., and give all this detail. Well, under my enhanced DUI, they're going to say all this thing the first time, and I'm not going to care, because whatever they say, I'm getting transcripts. And when I get those transcripts and I ask them a second time the same question and that officer says something different, what do you think I do to them? They aren't going to be very happy. They're not going to walk out of there very happy, and basically I'm going to destroy them on the stand because I can show that they lied. So that's how the enhanced helps, and it does help a lot. It gives me a lot of tools. If I can get a witness to talk multiple times, I can usually catch them in a lie, and that's what it's all about. Now, I've just gone over general parameters from DUI cases. As I said in the beginning, not every case is the same, and some cases have worse facts and better facts. But in a general sense, every case is winnable. And the only way you're going to know is to try it. So if you're not here, I hope this gave you some information that can help guide you on your choices in this case. If you are here, I'm going to come out and talk to you now. Bye-bye.